Thank you very kindly, my lords, my lady. I'll only highlight a few issues which are legal. I'll move from Article 1 of the Constitution, your lordships. That Article 1 has created organs of government. Among them is the organ of the judiciary. And it has clearly provided, your lordship, that the people of Kenya, in exercise of their sovereignty, they have delegated their powers to those organs. In this case, the power under Article 165, Clause 4, is exclusively delegated to the Chief Justice. Your lordship, in administrative law, it's right that a person who enjoys delegated powers cannot further delegate those particular powers. In this case, in this circumstance, your lordship, it is not known to the petitioners under what circumstances the Chief Justice may have delegated these powers to the Deputy Chief Justice. It is our humble submission, your lordship, that the powers and the functions under Article 165, Clause 4 are not capable of being delegated. Further to that, your lordship, you seek leave under Article 159 of the Constitution, which provides that, your lordship, that judicial power is derived from the people and shall be exercised by the courts and tribunals established by this Constitution for and on behalf of the people. That article again clearly indicates that this power under Article 165 Clause 4 is not capable of being delegated. How about, your lordship, in the Constitution? Your lordship, I invite you to look at Article 260 of the Constitution. It provides if a function has been created to be executed by that particular organ, it is only that organ that is capable of executing that particular function. And for the question of further delegating that particular function cannot arise so as to say that the Deputy Chief Justice had the constitutional mandate to appoint this bench to adjudicate over these particular files. Your lordship, we have put up a case that the Deputy Chief Justice has not only violated the Constitution, but also violated the rights of the petitioners to be heard under Article 50 of the Constitution. When they move to appoint a bench of this, the bench, and fail to notify the parties herein as evidenced by the counsel appearing for the petitioner in petition number 14, it tells your lordship that the expediency for which it was done was so as to meet the objective of setting aside the orders that were granted by your brother Justice Mwongo and your brother Justice Mwita. Your lordship, when you retire to make a ruling of our application, it is important that you pay serious attention to paragraph 12 of our affidavit, paragraph 21 again of the affidavit, paragraph 22 again, and also paragraph 27. And then you might want to ask yourself, under section 10 of the High Court Organizations, High Court Administration and Organization Act, how, under what circumstances, the Chief Justice, the Deputy Chief Justice, authorize you to sit on a Saturday? Under what circumstances did the Chief Justice herself, Deputy Chief Justice herself, sit at night, in the wee hours of the night, ungodly hours, and constituted this bench? Your lordship, it's our humble submissions that Article 10 has only arrogated that function, again, exclusively to the Chief Justice. And that the Deputy Chief Justice has no power under Section 10 of the High Court Organization and Administration Act to order you or to authorize you to sit on an odd day like that or the Saturday. Your lordship, permit me to draw your attention again to the case of Omtata. When you retire and the judgment will be highlighted by my learned friend, it is of importance, your lordship, that you look at paragraph 192 of that judgment. It has given the circumstances under which the Deputy Chief Justice can act in the absence of the Chief Justice. One is if the Chief Justice is indisposed, if he resigns, if he is dead, or if he is holded out of office. The question of leave, to which we are submitting without knowledge whether that is the circumstance that led to the allocation of powers by the Chief Justice, is not one of the grounds or reasons that the Chief Justice can exercise, the Deputy Chief Justice can exercise the exclusive powers meant for the Chief Justice. Finally, Your Lordship, all these averments contained in our affidavit have not been controverted by the respondents through a replying affidavit. They have only filed the grounds of opposition, to which they shall bring to your attention the case of Container, which has been distinguished by the case of Okia Omtata. The grounds contained in our affidavit, Your Lordship, are uncontroverted and they must be admitted as such. I beg to rest my case.
May we request counsel to give us specific reference to Okia Omtata has been mentioned by two counsel. He's probably the most prolific litigator in the history of Kenya.
I will certainly be addressing my senior at the bar and senior at the academy, Professor Ndegwa Njiru. It was a pleasure being with him in court. A man or woman who plants a tree, not knowing fully well that they will not sit in its shade, knows the meaning of life. You sit today in such an epochal moment that what you do here has significant ramifications for the Republic of Kenya. It is for you as a court to rise to the occasion. This court has defined the Constitution as a transformative Constitution. And this was done by this very court, differently seated in the BBI case, David, Ndi, and others, versus the Attorney General. And this is what the court said about the Constitution 2010. It is a constitution of a transformative character. And this transformative character of the Constitution induces large-scale social change, including the character and conduct of politics. That the Constitution bears an internal theory of interpretation. Starting point for discerning that internal theory is Article 259 of the Constitution. That formalistic approaches to constitutional interpretation are not favored. The other side has filed grounds of opposition, and in their grounds of opposition they raise a case, Lona Conchela and others versus the Chief Justice. That was the grounds of opposition by the Attorney General. And in that case, this High Court said that the power to appoint a bench is administrator, and that that power can be performed by the Deputy Chief Justice in limited, constricted circumstances, so that the normative holder, the Chief Justice, performs it, but the Deputy Chief Justice has to perform it in certain limited circumstances. Those limited circumstances have to be demonstrable. That is Conchela. Your Lordship Justice Murima, sitting in Okoiti versus JSC and another petition, E408-2020, 2021 EKLR, I believe that is what Professor Ndegwa Njiru was asking about. Paragraph 29 to 38. Justice Murima finds that the authority under Article 165(4) is a constitutional authority, so that that authority cannot be delegated by the Chief Justice, because the Chief Justice does not cease to be a state officer, even on leave. We have another authority here, Petition 31 of 2013, Kenya Medical Research Institute versus the Attorney General. This is found at 2014 EKLR at paragraph 37. Kenya Medical Research Institute versus the Attorney General and 3 others, 2014 EKLR. This case at paragraph 37 says this, that the Chief Justice under Article 165(4), the authority to empanel a bench, performs a constitutional mandate. And this is not an administrative function, as was in the old constitution. Where do we go? I'll invite the court to look at the express wordings of Article 259(3)(a) that expressly decrees that authority granted to a specific office must be performed by that specific officer. That is Article 259(3)(a). I'll want this court to consider the decision of the Court of Appeal, and this, the other side can take judicial notice of, the court can take judicial notice of the case of Karisa Chengo, whereby the office of judge and the person of judge are synonymous. So that the Chief Justice, the person, and the office of Chief Justice are synonymous. And therefore, we cannot separate and delink the holder and the person. And therefore, if the Chief Justice were to delegate any responsibility to the Deputy Chief Justice, assuming that was possible, then the Deputy Chief Justice has to take an oath by virtue of Article 74 of the Constitution. There has to be instruments prepared authorizing the DCJ to act as Chief Justice, and for what purposes? Ladies and gentlemen, Honorable Court, the Greek tale of Ulysses, the coxswain who was asked to block his ears using wax and to avoid the temptation of alluring music, that story echoes well for you today. There's politics, there's a lot of heat and rancor, but for you, as the court, an apex court under the Constitution, yours is to uphold and defend this Constitution as required at Article 3. That's the sole mandate of this court. Thank you.